Dear Chief Acosta, I registered my claim in 1995 on the certificate of title covering a land which I believe was fraudulently registered in the name of my half-brother. Unfortunately, I also found out that the property was mortgaged to LC in 1992. When my half-brother failed to pay his debt, LC foreclosed the mortgage and emerged as the highest bidder in 1998. Can I consider LC to be a buyer in bad faith because he became aware of my claim when I registered it in 1995, and yet he still purchased the property in 1998? Which right should prevail? Hesselof.
Dear Hesselof, it is important to emphasize that the mortgage contract between your half-brother and Elsie was registered in 1992 or 3 years earlier than the registration of your claim. At that time, Elsie had no knowledge of your claim yet, as such information was made known to him in 1995. As such, Elsie is considered as a mortgagee buyer in good faith. This is in accordance with Section 44 of Presidential Decree Number 1529 or the Property Registration Decree, which provides that
every registered owner receiving a certificate of title in pursuance of a decree of registration and every subsequent purchaser of registered land taking a certificate of title for value and in good faith shall hold the same free from all the encumbrances except those noted in said certificate.
corollary thereto, the Supreme Court, speaking through Honorable Associate Justice Mario V. Lopez, in the case of Danilo Santiago Jimenez versus Damian Jimenez et al., stated that
In sum, jurisprudence dictates that a subsequent lien or encumbrance annotated at the back of certificate of title of a foreclosed property will not affect the rights of a purchaser in a foreclosure sale, because such sale retroacts to the date of the registration of the mortgage, making the sale prior in time to the lien or encumbrance. The foreclosure sale retroacts to the date of registration of the mortgage because it is incidental to the fulfillment of the mortgagor's obligation in the mortgage contract upon his default. In turn, the purchaser in a foreclosure sale essentially derives his right from the previously registered mortgage. To rule otherwise would be to render nugatory the purpose of the mortgage as security. Furthermore, we stress that the nullity of the mortgagor's certificate of title does not automatically carry with it the nullity of a registered mortgage if the mortgagee acted in good faith. Once the mortgagor defaulted in the fulfillment of his obligation, the mortgagee, in good faith, can still cause the foreclosure of the mortgage. In such case, the purchaser in the foreclosure sale acquires the right of the mortgagee in good faith, making the sale prior in time as against in any subsequent lien or encumbrance.
applying the law and jurisprudence in your situation, Elsie's right as mortgagee purchaser in good faith in the foreclosure sale will prevail, considering that your claim was registered subsequent to his mortgage. Your claim will not affect Elsie's right as the purchaser in the foreclosure sale, considering that the foreclosure retroacts to the date of the registration of the mortgage, it being incidental to the failure of the mortgagor to fulfill his obligation in the mortgage contract. To restate, the purchaser in a foreclosure sale is actually deriving his right from the time the mortgage was executed. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Persida V. Rueda Acosta, DSD, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.